Good evening, honorable dignitaries, ladies and gentlemen.
A very warm welcome to all of you to this evening for the inaugural event of the lecture series organized by the Kerala High Court Senior Advocates Association as part of the celebration of Constitution Day. We are truly privileged to have such a distinguished gathering of judges, lawyers, and other esteemed guests here with us today.
I respectfully invite Senior Advocate N. Nandakumara Menon, President of the Kerala High Court Senior Advocates Association, Honorable Mr. Justice Nitin Jamdar, Chief Justice of the High Court of Kerala, Senior Advocate Sudhish Pai, and Senior Advocate George Cherian onto the stage to formally commence the function.
Thank you all.
I would like to request everyone to please stand up for a silent prayer. Thank you. Kindly take your seats.
It is now my pleasure to invite Senior Advocate N. Nandakumara Menon, the esteemed President of the Kerala High Court Senior Advocates Association, to deliver the welcome speech and presidential address and set the tone for this memorable evening.
Honorable Chief Justice, Mr. Justice Nitin Jamdar, esteemed judges of the Honorable High Court, Mr. Sudhish Pai, the Chief Guest of the evening, Senior Advocates, Learned Additional Advocate General, Mr. Ashok Cherian, Director General of Prosecution, Mr. T.S. Haji, Additional Director of Prosecution, Mr. Gracious Kuriakos, President of the Kerala High Court Advocates Association, Mr. Yeshwant Shenoy, and President of the Kerala Federation of Women Lawyers, Mrs. P.K. Sandamma, members of the bar, ladies and gentlemen. Today we have assembled here for listening to Mr. Sudhish Shenoy, who is a well-known writer, author, a constitutionalist, who has kindly consented to our request to be with us this evening to deliver a speech on the subject 75 years of the Constitution and the Court, a fascinating journey. Now, I will be, while discharging my duty to welcome the august gathering and also the distinguished guests, it is my duty to express our gratitude to the Honorable Chief Justice for having helped in all ways possible for the Kerala High Court Senior Advocates Association to function and extending his helping hand for all matters for which you have approached him. Sir, I, on my own behalf and on behalf of the Kerala High Court Senior Advocates Association, welcome you, sir, to the occasion. Mr. Sudhish Pai is a well-known constitutionalist, a very leading senior lawyer in the Supreme Court of India, and I don't think that he requires any introduction to the gathering because he is so well known in the field of law. In all the subjects under the sun in the legal in law is known to him, and it is my duty to give a short profile of this distinguished lawyer. He is an author, acclaimed author, specializing in constitutional law, civil law, and also administrative law. He is a member of the Indian Law Institute, New Delhi, member of the Karnataka section of the International Commission of Jurists, contributor to the restatement of Indian law on legislative privileges. One of the main contributors to the book Courts of India 2016, brought out by the Supreme Court of India, was also the visiting chairperson of Mukherjee Chair at West Bengal, National University Judicial Sciences, Kolkata. Resource person is also the resource person of National Judicial Academy, Bhopal, for continuing legal education for judges, including judges from abroad. He is very much associated with the Law Commission, Karnataka, as a research scholar. His commendable works in the area of critical constitutional analysis includes, I shall name a few books he has written: The Legends in Law Over Great Forebears, 2021, Working of the Constitution, Checks and Balances, 2014, Constitutional Supremacy, a Revisit, Essays on Constitutionalism, and Rule of Law and Constitutional Adjudication, 2019. His latest book, 75 Years of the Constitution, Supreme Court's Role in Promoting Constitutionalism, will be published soon. Mr. K.K. Venugopal, former Attorney General of India, has said about the above work, as I quote, Sudhish Pai's work is a fascinating read for anyone interested in the voyage of foundational document of the world's largest democracy. The former Chief Justice of India, Mr. Sri M.N. Venkatachalam, in his foreword has said, quote, I quote, a jurist's contribution to the evolution of our Constitution and a creative role of Supreme Court of India. He is the present revising editor of the classic work, V.G. Ramachandran's Law of Writs. He is also a recipient of several literary awards on constitutional law and service law. His achievements and contributions to the field of law is highly commendable. He is a profound legal philosopher in the lineage of great commentators like Sirwai and Basu, and he is famous for his invaluable contributions for the rigorous regeneration of a healthy and informed discourse of vital public law issues. Sir, I, and also on my behalf and also on behalf of the Senior Advocates Association, are deeply obliged and indebted to you for having accepted our invitation and to be in our midst this evening as part of this August gathering and agreeing to deliver a speech on an important constitutional topic namely 75 years of Constitution and the court a fascinating journey. I welcome you, sir, to this august gathering. I also would like to bring to your kind notice that our Honorable Chief Justice will be doing the discharging the duty of the inaugural address by making a short speech. Because I say short speech, there is a reason for that. When I went to invite him for this function, first he reluctantly said that the time is too short for him to prepare a speech, a detailed speech. But anyway, I will join you for the occasion by delivering a short speech. We are very much thankful to you, sir, for your kindness. Thank you.
Thank you, sir.
We are now honored to proceed with the inauguration of our lecture series. The lamp symbolizes the enlightenment we seek through knowledge. I request Honorable Mr. Justice Nitin Jamdar, the Honorable Chief Justice of the High Court of Kerala, to kindly come forward to perform the lighting of the lamp and officially inaugurate the event. I request all of the dignitaries on the dais to please join our Honorable Chief Justice.
Thank you, Your Lordship, and all the other dignitaries.
May I kindly invite Honorable Mr. Justice Nitin Jamdar, the Chief Justice of the High Court of Kerala, for delivering the inaugural address.
My sister and brother judges were present here, President and office bearers of the Kerala High Court Senior Advocates Association, Mr. Sudhish Pai, today's speaker, law officers, senior advocates, members of the bar, ladies and gentlemen, a very good evening to all of you. It's very thoughtful of the association to organize this function on 9th December, which is the day of first sitting of India's Constituent Assembly in 1946. Thank you also for inviting me to preside over this function. In last 3 days in this very hall, we had a good fortune of listening to some of brilliant talks. And I am sure that we have a treat in store today as well. That also means this is my third speech in a row. Therefore, I had mentioned to the president of the association, that I would like to keep it short. Also because I'm more of a listener than a speaker, which is also a job requirement. But I will share a few of my thoughts on the role of legal fraternity in the context of Constitution and the rule of law that is enshrined under it. The main theme of my short speech would be only this, that the true impact of the justice under Constitution is created in the daily actions and procedure that shape delivery of justice. These actions may seem routine, but their importance cannot be overstated. The Constitution, in its wisdom, provides a framework for justice, equality, and fairness. It is through actions and procedures of the judiciary that this framework comes alive. Acceptance of judicial orders, the cornerstone of any legal system, rests on one fundamental principle, that is fairness. Fairness of judicial process earns society's respect and trust. It ensures every litigant, regardless of their circumstances, feel that they have been heard and treated with dignity. Fairness is not an abstract concept. It is brought to life with some concrete concepts. These are providing both sides an opportunity, ensuring impartiality at every stage of the proceedings, conducting hearing in open and transparent manner, and delivering orders that are supported by reasons. When these principles are adhered to, the decisions rendered are not only lawful, but they are seen to be just. Perception of fairness is critical because it strengthens this rule of law. Legitimacy of rule of law is not built overnight. It is built incrementally, case by case, decision by decision. Each judge, each lawyer, each court staff plays a pivotal role in this process. Every step, from the smallest procedural order to most complex constitutional rulings, contributes. That is because rule of law, as enshrined in our Constitution, cannot be taken for granted. It demands our constant vigilance and unrelenting effort. The essence of justice under Constitution is not found in the dramatic. There is no magic wand to change the society or solve society's all problems. Instead, it is achieved in the unglamorous, routine work of the judiciary. The magic lies in the daily work of each judge, each lawyer, and each staff member involved in it, addressing the rights and grievances of each litigant, each case before the court. It is found in the seemingly mundane litigation, the bail application, second appeals, service matters, property disputes, and countless all matters that come to the court. Each matter, no matter ordinary it may seem, carries with him a requirement to do justice, both procedural and substantive, that maintains the rule of law. In the end, all I want to say to the legal fraternity is only this, that the philosophy of justice under our Constitution is present in every case. Be still, listen to it, and you will hear its call. Answer that call every time. That will be your tribute to this great Constitution. Thank you.
Thank you, Your Lordship, for your insightful words.
We are now set to move forward with the highlight of today's function, the lecture. It is my pleasure to introduce our esteemed speaker for the evening, Senior Advocate Sudhish Pai, who will be delivering the lecture titled 75 Years of the Constitution and the Court, a Fascinating Journey.
His works include Legends in Law, or Great Forebearers, Working of the Constitution, Checks and Balances, The Judicial World of a Multi-Splendored Genius, Sir Ashutosh Mukherjee, and Sir Ashutosh Mukherjee's Judicial World Through Judgments. a judge, non-parole, a B.K. Mukherjee reader, Constitutional Supremacy, a revisit, essays on constitutionalism, rule of law, and constitutional adjudication. Justice Yemman Venkatacharya, the man and the judge. Soli Sorabji, a great maestro. He is the current revising editor of the classic work V.G. Ramachandran's Law of Writs. He is also the revising editor of Professor T.K. Top's Constitutional Law of India, the 4th edition of which is to be published soon. His latest book is 75 Years of the Constitution, the Supreme Court's role in promoting constitutionalism.
He has been conferred the Scotch Literature Award for The Man and the Judge, a Venkatacharya reader, and the Scotch Award for Exemplary Service to Law. He has also been given the Capital Foundation Professor Ubendra Bakshi National Award for remarkable and distinctive contribution to law, particularly constitutional law and administrative law, legal research, and legal literature. The Capital Foundation Advocate General Sri S.G. Sundaraswamy Centenary Award has also been conferred on him this year in recognition of his outstanding contribution to legal scholarship. Without further ado, I now invite Senior Advocate Sudhish Pai to kindly deliver the lecture.
Honorable the Chief Justice, Honorable Judges, esteemed members of the Bar, invitees and friends. I am deeply sensible of the honor of this invitation to be with you this evening and share some thoughts on a topic of vital interest and significance. My joy today is enhanced by the fact that in a way this is homecoming. I have my roots here in Kochi, and therefore I am doubly happy to be with you today. This is the 75th year of the Constitution, the Republic, and the Court, Supreme Court. A matter for celebration, reflection, introspection. It's but appropriate that we sit back and reflect upon what has been and what should be. The aspiration to make power impersonal and its exercise accountable has been the motivation for constitutions and constitutionalism. Constitutionalism is an attempt to establish the supremacy of law. Men throughout history have longed for a higher standard by which our own man-made laws may be tested. Constitutions are that higher standard. The belief that individuals have natural rights, inherent and inalienable, which are anterior to any written instrument like a constitution, that government acquires its authority from the people. The purpose of government is to promote the common good. This is what conceives and conceptualizes a constitution made in the name of the people, defining the powers of the main institutions and delineating the relationship between the various organs of government and between government and the citizens. It is framed for ages to come and designed to approach immortality as nearly as human institutions can, to quote the memorable words of Chief Justice Marshall. A constitution, as we all know, refers to the document, while constitutional law is what is evolved by courts in interpreting the document. A constitution is the very lifebreath of a nation and the vehicle for its progress. It is, as we all know, the supreme law. It's about division, distribution, and management of state power so as to prevent arbitrariness and establish accountability to law. It's a framework of political society organized through and by law in which law has established permanent institutions with recognized functions and definite powers. A constitutional state is one in which the powers of the government, the rights of the people, and their relations inter se are adjusted. The term constitutional government is applied only to those governments whose fundamental rules not only locate the sovereign power in some person or bodies of persons chosen in a prescribed manner, but also, and very importantly, define the limits of its exercise so as to protect individual rights and shield them against the exercise of arbitrary power. All states with some constitution or the other purport to govern for the welfare of the people. But what distinguishes a democratic state from a totalitarian one is that a free democratic state respects certain basic human rights and endeavors to achieve its objectives through the discipline of fundamental freedoms. This is what constitutional government really signifies. The objectives of a written constitution in democracy are generally threefold: to establish the framework of government, to delegate or assign powers to the organs of the government, and to restrain the exercise of those powers to preserve individual rights. Constitutions, it is famously said, provide the means to guard against the state's capacity for invading liberties available and guaranteed to civilized people. A modern constitution empowers citizens and controls and disciplines power. The Constitution embodies and expresses the goals and aspirations of a people, depending upon the history of the society. It contains certain core values and beliefs which cannot be tinkered by a transient public opinion. The limitations imposed by constitutional law on actions of government are essential for the preservation of public and private rights, notwithstanding the representative character of political institutions. The aim of all good government is to bring about the security, welfare, and happiness of the people, and of the different forms of government that mankind has conceived. Democratic government with a Bill of Rights comes closest to the ideal for the attainment of these objectives. Every constitution has several aspects. It is first essentially a historical product. Secondly, it expresses some philosophy, political, economic, and social, primarily of the makers. It's a political instrument in the third place for good governance, seeking to make an adjustment between the political forces operating in the body politic. And fourthly, it has its legal character with which we as students of law are generally concerned. This legal aspect is what empowers the court to exercise the power of judicial review and grant relief. This aspect, emphasized by the American Supreme Court in Marbury versus Madison, has been incorporated in different provisions of our Constitution and in many constitutions across the globe. The Constitution of India, whose 75th anniversary we now very proudly celebrate, is one of the most comprehensive and well-drafted in spite of its elephantine size. It's perhaps one of the finest creations of human ingenuity. The Constitution represents a high watermark of consensus in India's political history. It manifests the best in our tradition. It provides a considered response to the needs and aspirations of the present and possesses sufficient resilience to cope with the problems and requirements of the future. It's an instrument drawn with such meticulous care by a remarkably wise, articulate, erudite pantheon of persons of outstanding ability and background who so well understood how to make language fit their thought and vision. The assembly was composed of persons of the highest caliber, drawn from different sections of society and representing various shades of opinion. The debates and discussions were of a very high order, profound, not marred by any narrow ideas or viewpoints, As you all know, the debate on the 17th of October 1949, when the preamble was to be adopted, because the preamble was the last, though it's at the beginning of the Constitution, it was adopted at the end, because it should reflect what the Constitution contains. And the debate on the principle of fraternity, which underpins the entire Constitution, but an expression we don't find anywhere in the body except in the preamble. The debate on fraternity verily rose to spiritual heights. Please see the speeches of Acharya Kripalani and many others. They were not just political heights, they were really spiritual heights. The presence and participation of a vast, inclusive cross-section of the society imparted a non-partisan character to the deliberation and enhanced the Assembly's authority and facilitated a general acceptability of the document. The Constituent Assembly, it would not be wrong to say, raised a magnificent temple of liberty based on the message of unity in the mosaic of diversities and forward-looking national self-confidence. Accommodation and concord underpin and characterize the Constitution. The Constitution Assembly met for the first time on December 9, which is today is the anniversary, and it's but appropriate that we have this function today. On December 9, 1946, and the inaugural session was presided over by the Provisional Chairman, Dr. Sachidanand Sinha, a lawyer of profound learning, a consummate advocate, known as the founder of modern Bihar, one of the earliest doctorates of law of the Allahabad University. Dr. Sachidanand Sinha was all this and more. And his inaugural speech is something, verily a gem, which I think all of us as people of India should read as a holy text, where he quoted Joseph's story and ultimately reminded us that the Constitution is safe as long as we are its custodians and discharge our responsibilities. The Objectives Resolution, drafted and moved by Pandit Jawaharlal Nehru on the 13th of December 1946 and adopted after a full-fledged debate on the 22nd of January 1947, is really the edifice on which, or rather the foundation on which the edifice of the Constitution was built. It provided the basis and the inspiration for the constitutional document. The deliberations, as we all know, lasted till November 26, 1949, when the Constitution was adopted. To give you some interesting details, which all of you may know, the Assembly's sittings were spread over 1,084 days, 2 years, 11 months, 17 days. It held 11 sessions covering 165 days, of which 114 were devoted to the consideration of the draft Constitution. And the cost of this entire noble venture was 69,96,729 rupees. And about 53,000 visitors were admitted to the visitors' gallery when the Constitution was being debated and considered. The Indian Independence Act 1947, passed by the British Parliament, was repealed, underscoring the idea of the Constitution being entirely Indian. This then is the saga of our Constitution, which according to Granville Austin was the greatest political venture since that originated in Philadelphia in 1781. I think the Assembly was composed of extraordinarily great men, but perhaps three names we would always remember. Dr. Ambedkar, of course, the chairman of the drafting committee, is a name too well known to bear repetition. But two other equally important names whose service to the nation perhaps is not that well acknowledged are Sir Benegal Narsingh Rao, the constitutional advisor to the Constituent Assembly, speaking of whom Justice Frankfurter said, if the President of the United States were to ask me for one name to be appointed to the American Supreme Court, Sir Benegal Narsingh Rao would be the first on my list. And equally important, Surendranath Mukherjee, S.N. Mukherjee, who was the Joint Secretary of the Constituent Assembly, and one who drafted every article of the Constitution and gave it its final shape. And if you read the speech of Dr. Ambedkar on the 25th of November 1949, on the eve of the adoption of the Constitution, paying tribute to both Sir Benegal and Surendranath Mukherjee, Dr. Ambedkar says, but for them, our work would have taken a considerably longer time. That the Constituent Assembly was able to wind up its proceedings and adopt the Constitution on the 26th of November 1949 is to a large extent due to the untiring efforts of Surendranath Mukherjee. The Constitution has undoubtedly drawn from many sources. It's a happy blend of many strains. In particular, the Government of India Act 1935 is the edifice on which the Constitution has been raised. But there's nothing wrong in borrowing, in adopting and adapting. As Dr. Ambedkar said, there is nothing wrong to be ashamed, there's nothing to be ashamed of in borrowing. It involves no plagiarism. No one has a patent right on the fundamental ideas of a constitution. And as the great French philosopher Voltaire remarked, originality is nothing but judicious imitation. The most original writers have always borrowed one from the other. It is therefore appropriate that on this occasion, we remember with gratitude and reverence the founding fathers and their contribution to the constitution making. Professor Upendra Bakshi has very perceptively remarked, we live in an era of massacre of ancestors, which we now consider a public virtue and a sign of progress. But collective amnesia of what happened in the past is not an estimable value. Without living in the past, its recall is important, for it necessarily presages a future. We cannot forget or overlook the enduring relevance of the past or its torch bearers. It is in that spirit that we remember and pay homage to the founding fathers. There are two fundamental ideas which underpin the Constitution. The value of liberty, the idea that will and not force is the basis of government. And the value of justice, that right and not might, is the basis of all political societies and every system of political order. In fact, John Locke's social contract theory that law is the expression of the will of the people is largely reflected in our Constitution as well. As with most modern constitutions, the opening words of the preamble emphasize the ultimate authority of the people from whom the Constitution is emerged. The preamble is the declaration of our faith and beliefs in certain fundamentals of national life, a standard from which we must not depart, a resolve which must not be shaken. The emotive words, justice, liberty, equality, fraternity, open up a vast music of hope. They are words of power and passion, and may be truly said to be the spiritual pillars on which the Constitution rests. These concepts, as also the idea of constitutionalism and the rule of law about which the Chief Justice spoke so eloquently, are the bedrock on which a conflict-free society really rests. Peace is the fruit of justice, and a peaceful society is what all of us look for. Justice, said Daniel Webster, is the greatest interest of man on earth, is the ligament that binds human beings and societies together. It's the cements the fabric of a secure society. Our Constitution, as Palkiwala very eloquently and elegantly said, represents a charter of power granted by liberty, not a charter of liberty granted by power. Apart from providing a broad framework of the government, it endeavors to protect liberties and secure justice. That is the constitutional vision and the goal. The justice provisions in Part 4 are fundamental to the governance of the country and underlie all human development. Democracy is not just a legal, formal concept, it is also a social idea. And the Constitution is not merely a legal document, it is essentially a social testament and a political instrument. It provides for stability without stagnation and for growth without destruction of essential values. A majority of the provisions are aimed at furthering the goals of the social revolution. Thank you. The core of the commitment lies in parts 3 and 4, which together with part 4A and the preamble may be said to represent the Constitution's conscience, the judiciary is the conscience keeper. The rule of law is the subordination of subservience of the executive to the legislative will, that every executive action must have the support or backing of law. It is concerned not only with what government may do, but more significantly, what legal powers government ought to have. But more importantly, in a country like ours, with a written constitution and a justiciable Bill of Rights, we have not only the rule of law, but what is picturesquely described, we have the absolute reign of law. Even the legislature is subservient to constitutional rights, values, and limitations. And that is the concept of the absolute reign of law. In India, we have both. The fundamental freedoms and human rights, I don't think there's much need to talk about that, except to say that they are not the gifts of any law or the Constitution. As Professor Edward Corwin, one of the most eminent scholars of American constitutional law, said, they owe nothing, that is human rights, fundamental freedoms, owe nothing to their recognition in the Constitution. Such recognition was necessary if the Constitution was to be regarded as complete. And Thomas Jefferson, writing to James Madison in 1787, said a Bill of Rights is what people are entitled to against every government on earth. And the historical and political developments in India during the time of the freedom movement made it inevitable that a Bill of Rights, or fundamental rights as we call them, should be enacted in the Constitution. There's one important feature that I would just like to mention in the passing. There is no provision in our Constitution corresponding to the 9th Amendment to the US Constitution, according to which the American people are not denied the enjoyment of other fundamental rights because of the fact that the Constitution enumerates certain rights. That means that whatever is not expressly withheld is also available to the people. The enumeration of certain rights is not to be construed to deny or disparage other rights retained by the people at large. This is understood and interpreted as an invitation to identify unenumerated rights. Of course, in India, we cannot generally claim any fundamental right outside the chapter on fundamental rights, but this is the beauty. This has not prevented our courts from expounding new rights as emanations of enumerated rights. This is one of the most fascinating sagas. Indeed, a few years ago, we counted that there were more than 25 rights that were read into Article 21 alone. The Constitution being the supreme law, no organ or institution has unfettered powers, and in a constitutional democracy, what obtains is what we call constitutional supremacy. A limited government and judicial review constitute the essence of our constitutional system, as Dr. Durgadas Basu put it so beautifully in his Tagore Law Lectures delivered in 69, published in 72, limited government and judicial review. And he says this involves three elements: a written constitution setting up and limiting the various organs of government, the Constitution functioning as a superior law or standard by which the conduct of all organs of government is to be judged, and a sanction by means of which a violation of the superior law by any organs may be prevented or restrained. That sanction in modern constitutional world is what we know as judicial review, which means a court of competent jurisdiction has the power to invalidate the act of any government agency, including the legislature, on the ground that it is repugnant to the Constitution. The structure of our government under the constitutional scheme is so designed, very beautifully designed, that each branch may be said to be a sentinel on the qui vive against the other two, so that none becomes too powerful or autocratic. The court's fidelity to the Constitution secures its own subordination, though it is the last word in the matter of interpretation, and is the final judge of all acts purported to be done under the authority of the Constitution. But as Justice Frankfurter very elegantly told us, fidelity and creativity are not necessarily opposed to one another. In fact, with devoted insight, they enhance each other. To quote that great constitutional lawyer and visionary, M.K. Nambiar, in an unpublished article, The Contours of the Constitution, this is what he wrote. Every system of government that is born out of revolution, violent or non-violent, bears the indelible impress of the impulses of its being. It mirrors the struggles of the past in its provisions to ensure the security of the future. It represents the aspirations, achievements, and ambitions of a people. No constitution is merely a collection of clauses or the handiwork of skilled draftsmanship. It's an organic growth springing from the forces of natural vitality and changing in color and content in the process of time. The constitutional experiments in India may be said to be a saga of statesmanship, hope, and faith. There were sublime moments. There were also times of anguish and travails, but the overall response of the Indian state, the democratic aspirations of our people, and the urges of Indian nationalism, I think we can safely say, has been one of great satisfaction. In his first inaugural address in 1801, President Jefferson made a beautiful remark qualifying the majority principle. And that's necessary, I thought, to link the subject of the Constitution with the court. All too will bear in mind the sacred principle that though the will of the majority is in all cases to prevail, that will to be rightful must be reasonable, that the majority possesses their equal rights with equal law, must protect, and to violate it would be oppression. This is, of course, reflected in Article 13. There are thus two institutions which appear to be fundamentally contradictory, but really not. The first is the institutionalization of the principle that the will of the majority must prevail. Government must conform to the will as per the democratic principle. As against this is the institutionalization of the equally important principle that government powers are limited. There are things which even a majority cannot do, as they are beyond the ambit of the legislature and the executive. The democratic ideal involves two strands. This was beautifully put by Lord Steen in the first Lord Cook lecture that he delivered in New Zealand maybe 20 years ago. First, the people entrust power to the government in accordance with the principles of majority rule. The second is that in a democracy, there must be an effective and fair means of achieving practical justice through law between individuals and the state and the individuals. Where tension develops between the views of the majority and the individual rights, a decision must be made, a balance must be struck. And the best way of achieving this purpose is for a democracy to delegate to an impartial and independent tribunal, the judiciary, this adjudicative function. Only such a judiciary, acting in accordance with the principles of institutional integrity, can carry out this task, and that alone will have democratic legitimacy. The judiciary owes allegiance to nothing but the Constitution and the constitutional duty of reaching through reasoned debate the best attainable judgments in accordance with justice and the law. Of course, at the root of all this is the struggle by fallible judges with imperfect insights for government under law and not under man. Democracy is essentially a balance between constitutional rights and public interests. And it is for the courts to maintain this delicate balance. This is what exactly President Aaron Barrack always speaks of in courts in a constitutional democracy, the task of maintaining the balance, that great, renowned ex-president of the Israeli Supreme Court. But all this is not self-executing. It's through the institution of the judiciary that this becomes alive. It's very often by judicial interpretation that you enliven and make purposeful the Constitution and the law. Done wisely, judicial lawmaking within limits is both laudable and legitimate. Judicial response to different fact situations varies and it is an accepted fact of constitutional interpretation that the content of justiciability changes according to how a judge's value preferences respond to the multidimensional problems of the day, and awareness of history is a part of these preferences. The rights and values envisaged by the Constitution are not merely material. Constitutionalism implies limited government. Public law has, Professor Wade puts it very beautifully, has seen a movement from a culture of authority to a culture of justification, where power and its exercise is made answerable. The judiciary, and particularly the Supreme Court, as a vital institution of democratic governance, has helped to inculcate and foster a culture which is the constitutional culture, and infuse state actions with a constitutional ethos. All seemingly wide and unfettered powers of the state are tempered by constitutional limitations to be exercised in accord with public law principles. But that's not all. This is the essence of the protection of political and civil rights, but the court has been equally solicitous of the socio-economic rights. The scheme for the realization of the socio-economic agenda comprises both the justiciable fundamental rights and the non-justiciable directives, and the judicial contribution to their synthesis and integration has been critical to the realization of the goals in Part 4, both as a means to effectuate the rights guaranteed under Part 3 and as a source of law for a welfare state. As we know, Part 4 directives are referred to as fons juris, sources of law. The Supreme Court, after the first 2 decades, harmoniously interpreted Parts 3 and 4 and has much to be proud of. But a cultivated respect for law and enduring institutions is important, as much by we the people. An unfailing index to the maturity of a democracy is the degree of its respect for unwritten conventions. What is left unsaid in a constitution is as important and eloquent as what is said, and the constitutional equilibrium can be preserved only by what is called obedience to the unenforceable. Obedience to the enforceable is nothing. Of course, a policeman will catch me and fine me if I break the signals. That's all right. That's what everyone do. Even the animals may do that. But I, as a cultured human being, cultured by the constitutional culture, must practice obedience to the unenforceable. That is the dharma of the situation. The first 15 years of the Supreme Court may be characterized by today's standards as a conservative era. The interpretation exposition was generally textual. However, the court, while giving deference to legislative wisdom, acted firmly in various areas in striking down impermissible legislations. But that was mainly in the area of fundamental rights relating to property, agrarian reforms, trade, business. It was also, of course, during this period that Article 14, the doctrine of equality, the concept of discrimination, non-discrimination, and the theory of classification were evolved, and that has stood the test of time. The court held, right at the very beginning of the Constitution, that freedom of speech and expression included freedom of the press. It has been rightly said, the initial years, the court was manned by a band of erudite, dedicated judges who, in the cases before them, generated a disciplined, learned debate free from bias or acrimony. Judicial power in their hands did not foreclose the future. The doors may have been often closed, but they were never bolted. The judgments of that era set the tone and direction along which subsequent journeys were made, and they laid solid foundations for the building for the future. The court defined various range of concepts and principles delineating their parameters. Thereafter, from the mid-60s, we see a perceptible change, with the court adopting a more activist approach. The Supreme Court took great strides in developing constitutional law. The greatest thing is what was the majority principle, majority dictum in Gopalan, that 14, 19, 21 are watertight compartments, and the very passionate, impressive dissent of Justice Fazl Ali, which became the law 20 years later, beginning with Rustam Cooper, the bank nationalization case, and then evolving with Maneka Gandhi, and of course Minerva Mills, where Chief Justice Chandrachud spoke of them as the Golden Triangle, Articles 14, 19, and 21. I think that was what really gave an impetus to the growth of our constitutional law. The great theme in the history of a constitutional law is the concept of law as a check upon power. That idea has been given practical reality in the decisions of the Supreme Court. Those decisions are, to paraphrase Justice Ohms, a virtual magic mirror in which we see reflected our whole constitutional development and all that it has meant to the nation. There are indeed many decisions which are commendable and trailblazing. It's startling to imagine today what would have been the position if these cases had not come up before the court and not been decided in the way they were. Today, down the years, many of them which shaped our constitutional law and helped it to be built brick by brick may seem very easy, simple, and in the natural course of things. But things did not happen overnight. We must remember that great judges molded the law and took it forward, most of the time slowly and cautiously. But they were truly revolutionary changes that were brought about. A shrewd US politician, referring to the Constitution, remarked, "We the people is an eloquent beginning, but when the document was completed on 17th September 1787, I was not included in that we the people. I felt somehow for many years Washington and Hamilton just left me out by mistake. But I realized that it's through the process of interpretation and court decision. This also describes the role of the Indian judiciary, particularly the Supreme Court. By interpretation and court decision, it has broadened the reach of the Constitution's provisions, making them more meaningful to the common man. The realization of the socio-economic agenda comprises both the justiciable rights and the non-justiciable principles, directive principles, and the judicial contribution to their synthesis and integration has been very crucial. The Constitution promised a peaceful revolution. The Supreme Court's contribution in that endeavor has been truly astounding. It may be said that human rights and public interest litigation reinforced each other. In the evolution of our constitutional law and judicial experience, there is evident a continuous flow of thought as to how values of human rights and international instruments can inspire constitutional interpretation for establishing an egalitarian society. Natural justice came into its own. The distinction between administrative act and quasi-judicial functions were obliterated. The right of being heard was held to be an essential requirement of all actions having civil consequences. In state action became non-negotiable. The doctrine of promissory estoppel was placed on a foundation. The frontiers of constitutional law and administrative law were carried much further. The right to life and liberty received an explosive expansion with cases relating to prison reforms and rights of under trials. The law, particularly criminal law, was humanized. The evolving jurisprudence of death sentence infused that area of the law with constitutional values. Article 21 reached its full plenitude, to use the language of Justice Bhagwati, after Francis Carlyle Mullen, that life is not mere animal existence, but it is to live with dignity, and the inhibition against its deprivation extends to all limbs and faculties by which life is enjoyed. Award of compensation in writ jurisdiction, public tort, Rudal Sa, Chief Justice Chandrachud's judgment, and the line of cases following that entirely changed the course. Olga Teles, a classic example of second-generation rights which were recognized by the court. Today, the judges have become trustees of a new conception of limited government, limited, that is, by constitutional law and transnational mandates. At the same time, they have also become trustees of an enlarged government, enlarged to fulfill the new goals of the social state. This is what, as you all know, Mauro Capelletti observes in his judicial perspective. And when we say trustees, we are reminded of what the standards of those trustees are. The standards of fiduciary conduct set by Cardoso for even an ordinary trustee is that he is held to something stricter than the morals of the marketplace. Not honesty alone, but the punctilio of an honor, the most sensitive, is the standard of behavior. What then do we say of a constitutional trust so noble and lofty? Roypa and the line of cases revolutionized the dimensions of Article 14. Maneka Gandhi infused new life into 21. All actions of state were to be non-arbitrary, beginning with the Rajasthan Assembly dissolution case, and then Bommai and Rameshwar Prasad. These are high watermarks of judicial review to check the abuse of Article 356. Vadva held that all powers were tempered with constitutional limitations, and a colorable exercise of power is anathema to our constitutional scheme. Epur Sudhakar reiterated the amenability to judicial review in the exercise of the pardon power. The doctrine of pleasure was subjected to constitutional culture in B.P. Singhal, a case dealing with removal of governors. Maharaja Dharmendra Singh is a significant case concerning private law, property law, and the nuances of public law and the interface between them, where one of the parties is state, all state actions must have a higher legal pedigree. And in the latest case of State of Punjab versus Governor of Punjab, if I may say so, the first time, the Supreme Court very rightly pronounced upon the nuances and parameters of Article 200. There was some kind of a mystery from 1963, Chief Justice Gajendra Gadkar's judgment in Purushottam Nambudiri, that essence it's non-justiciable. It is not. No power is non-justiciable in a constitutional scheme. Of course, the parameters and the nuances may vary. And Nambudiri's case was not one which dealt with assent at all. It was about prorogation of the assembly. So for the first time now, the parameters of Article 200 and the presidential or governor's power of assent has been, if I may say so very respectfully, delineated very correctly and emphatically. Because I've always held that view that it is amenable to judicial review. Of course, to what extent, those are matters, but to say that the doors are shut, you throw off your hands, no, it can't be. All these are instances of judicial review being invoked and enforced, to enforce limited government, limited by constitutional mandates, values, and limitations. In fact, in Bank of Cochin, about which we heard the other day, Justice Jaishankar Nambiar speak about Justice Krishna Iyer, and Vishaga, transnational mandates of international treaties and conventions not inconsistent with domestic law were called in aid to interpret national law. Well, the constituent power itself has been held to be limited in Keshwanand. Where any part of the Constitution may be amended, the amendment should not be such as would abrogate the essential features of the Constitution. This was reiterated in Indira Gandhi and Minerva Mills. The whole idea behind the doctrine is to ensure that by a process of amendment, the Constitution is not denuded of its core or made to suffer a loss of identity. It is framed and adopted. When it is framed and adopted, it tends to reflect the dominant beliefs of the people at that time. But a constitution must necessarily be susceptible to and capable of change. It cannot be frozen in time or ideas. And therefore it is important, and this is what I would like to very respectfully stress, that in appreciating an argument about violation of the basic structure or basic features, one cannot ignore the essential, organic, evolutionary character of a constitution and its flexibility as a living entity to provide for the demands and compulsions of changing times and needs. Now, coming to trustees of an enlarged government, the work of the court has been really admirable. It is this approach of balancing and harmonizing that has helped our society and the legal system to forge ahead with social welfare measures, endeavoring to create a climate of happiness and security. With all these measures, legislative measures of socio-economic rights in a way represent the myriad lights and shades of India's life, the contrasting tones of poverty and wealth, and bread so dear and life so cheap, the deep tints of adventure and enterprise, and man's ageless struggle for a brighter morn. Judicial interpretation led to the reading into and inclusion of various rights as emanations, successfully attempting to translate human rights rhetoric into reality. Bank of Cochin is also an example of the enlarged rights, so is Ratlam municipality. Statute law, common law, international instruments like treaties were resorted to enforce the obligations and realize the social goals. More than 60 years ago, I think in 1957, yes, Lord MacDermot in his Hamlin lectures spoke of law as a protection from power. In the decades that have gone by since then, public law, as we all know, has grown by leaps and bounds. Its tools have been innovated, sharpened, refined. The contours of judicial review have been drawn with sharper edges, and it effectively serves as a shield against the onslaughts of power of all kinds. Now, the march of science and technology, the interplay of economics and social sciences and law, and the influence of all this on the existing political and legal systems cannot be overlooked. How judicial power would have to respond to these changes is a very intricate, interesting, and serious question. I have not attempted to discuss that here. Whether it will is a question for another day, and if so, how is a question for another debate. But having said all this, the need and importance of constitutional exposition and the exercise of judicial power, particularly judicial review, I would respectfully submit it is also essential to enter a caveat. In the process of interpretation and deciding matters, judges do make law. That judges don't make law, as Lord Reed said, is a fairy tale long gone by. But law is molded and sometimes changed by this process, which is quite legitimate. However, this is always subject to legislative oversight in the sense that it is supposed to be ultimately amenable by the sovereign people, who through their representatives may change the law. That at least is the theory. It is, however, not uncommon these days for courts to exercise full-fledged legislative and executive power and travel into realms certainly not their own. In this process of legislating or issuing directions touching matters of law and policy, many constitutional limitations are undoubtedly breached. Legislative and executive actions are tested and corrected by the judiciary. But judicial action, if it partakes of both executive and legislative nature, leaves one aghast and remediless. If the salt has lost its savor, wherewith can it be salted? The judiciary, particularly the Supreme Court at the top of the judicial hierarchy, hands down various significant decisions in different fields. Our Supreme Court, in its 75 years of existence, has rendered momentous judgments which have molded the law, established a new principle, given the law a new shift or emphasis, and impacted the life of the people and the nation. And some have even influenced juristic thought and jurisprudential trends in other jurisdictions. It's also necessary to remember that even dissenting judgments can be landmarks and provide an impetus. Many times today's dissent becomes the law tomorrow. And therefore, in the evolution of the law, dissents play a very significant part. It's not inapposite to make another comment in this assembly. A good judgment is characterized by brevity and precision. Many judgments these days are extremely lengthy, verbose, tiring. One does not know what is decided. At least those who read lose their focus. I'm not sure of whether those who write retain theirs. Not often, they are characterized more by rhetoric. It's difficult to know what exactly a judgment decides. What is a judgment after all? It's for us to know what the court has decided. It is sheer journalism. Judicial statesmanship has given room to intellectual showmanship. Read the judgments of yesteryears and admire the profundity of ideas, the elegance of expression, but all that done pithily and with precision. This is not a criticism, but criticism essentially a matter of appreciation, and if we do not do that, I think it's not worthwhile being around. The memorable words of one of the framers of the American Constitution, James Madison: if men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great problem lies in this: you must first enable the government to control the governed, in the next place oblige it to control itself. A dependence on the people is undoubtedly the primary control on the government, but experience has taught mankind the necessity of auxiliary precautions. Judicial review and legal control of government is that auxiliary precaution, which is so very important and which all of us, lawyers and judges, must tend and see that it is on the track. Judges tend the gate between order and anarchy. The role and contribution of the judiciary, particularly the highest court, in realizing the constitutional goals has been impressive. The judgment of the Indian people will be that their constitutional rights are safe in the hands of the court, though on occasions the court might have not lived up to the trust and expectations of the people, and its judgments might have run counter to the better judgment of the community. But still, at the end of the day, in spite of criticisms, in spite of ups and downs, what was said by Chief Justice Hughes of the American Supreme Court way back in 1930, the famous Foundation Day laying speech of the present building of the US Supreme Court. This is what he said: the Republic endures, and this is the symbol of our faith, the Supreme Court. I think applies truly and equally to India. Just one more thought and I have done. In a study conducted about 15 years ago, 3 scholars, the endurance of national constitutions, say that the average lifespan of a written constitution is 19 years, 19. Hardly a few last 50. And the factors which they say help a constitution endure are specificity of its provisions, flexibility of the amending process, and inclusiveness. And I would add a robust judicial process. Surrounded by neighboring countries, which are like deserts where constitutions have come and gone and constitutional way of life is something fanciful, we can be really proud we are an oasis. Our constitution is 75 years old. No, I would say 75 years young. It must last for many, many more eons after all of us are dead and gone and the voices of today are lost in the silence of the centuries. The Sentinel volume, 14th Amendment, edited by Professor Bernard Squaws, contains an article, Landmarks of Legal Liberty, by that great judge, William Brennan, in which he writes, in the service of the age-old dream for recognition of the equal and inalienable rights of man, the 14th Amendment, though 100 years old, can never be old. Our Constitution and the court, too, stride in their majesty with youthful vigor. However old they may be, they can never be old. They will and should endure. As the stars that are starry in the times of darkness, to the end, they should be light and remain. The journey of the world's largest democracy, its foundational document, our sacred Constitution, and the Supreme Court expounded its meaning and content, has been truly fascinating. It is necessary for us to build and nurture a constitutional culture which people from generation to generation have to cherish and carry forward. Constitutional values and aspirations have to be internalized in our psyche. In a democracy, as Justice Frankfurter said, there is no office higher than that of a citizen. For democracy is always a beckoning goal, not a safe harbor, and freedom is an unremitting endeavor, never a final achievement. And therefore it is that we, the people, need to constantly remind ourselves the Constitution, our treasured inheritance, which we have to cherish, is presently in our keeping, and we at once its servants and its masters, renew and maintain our allegiance to the fundamental charter. And on an occasion like this, a very joyous occasion, the Platinum Jubilee of the Constitution, we can have no better wish than that the spirit of the Constitution animates our being and its light illumines all our thoughts, words, and deeds. Thank you very much for your patience and courtesy.
Thank you, sir, for such an enriching lecture. Your reflections on the fascinating journey of the Constitution and our judiciary were both insightful and thought-provoking.
I would now like to invite Senior Advocate George Cherian, Secretary of the Kerala High Court Senior Advocates Association, to deliver the vote of thanks.
Honorable Mr. Justice Nitin Jamdar, Chief Justice, Honorable Judges of this court, Senior Advocate B. Sudhish Pai, and my dear friends. We have come to the close part of the function. I am here to express our gratitude and thanks to you all. Chief Justice Nitin Jamdar inaugurated the function. He readily accepted our invitation and is with us. I extend gratitude and sincere thanks from the bottom of my heart. I also express thanks to all honorable judges who participated in this lecture. B. Sudhish Pai has given a good lecture on our constitution, its development. I extend deep, heartful gratitude to the speaker, Senior Advocate Sudhish Pai. I also thank you all for your great participation and making the function a grand success. Thank you.
Ladies and gentlemen, we have now come to the conclusion of the inaugural event of our lecture series. We extend our sincere gratitude to all our dignitaries for their valuable participation. It has been a privilege to host you this evening.
I request everyone to please rise for the national anthem.
भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मागे गाहे तब जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
On behalf of the Kerala High Court Senior Advocates Association, we extend our sincere thanks to each one of you for joining us